An introduction to about 1 minute. So please stand by. We won't be compressing anybody else's time, but we'll start in about 5 minutes or so.
Start. Good morning, everyone. Good morning, everyone. Thanks, everyone, for coming out on such a cold morning. My name is Helen Bernstein. I'm Counsel Program Development in the Department of Professional Development and Competence at the Law Society. I want to welcome you all to today's program. It's our 8th annual Intellectual Property Law Program, the Year in Review. I also want to mention that the program has been prepared under the leadership of the Law Society's Intellectual Property Law Specialty Committee. We hope you take some time to fill in the great course evaluation form. We want to mention that the program is being videotaped. I'd like to thank our chair, Don Cameron, a prominent member of the IP Bar, co-chair of Ogilvy Renault's IP Group in Toronto, and certified as a specialist in both IP and civil litigation. We also want to thank all our faculty members, and I'm happy to turn the podium over to Don.
Thank you. To keep the program brief, and Helen stole most of my material, I'd like to remind everybody that just as in the movie theaters, could you please turn off your personal communication devices so you don't receive any very important cell phone calls during the course of this. I'll also ask Don, if anybody does have any questions from the studio audience, if you could please repeat the question for the benefit of those watching on webcast. And I think it's pretty cool that we've got a system where we can broadcast this thing simultaneously over the internet to 5 or 6 other locations around Ontario, and yet in order for me to get Don's attention that he's only got 5 minutes left or 3 minutes left or 1 minute left, I have to throw these like a frisbee to the back of his head. So I think we'll have to do what the Supreme Court does and have the little lights up on the front here next time, and Wang in the sound system to turn the microphone off at when time's up. I'll let you know, Wang, when to kill Don's microphone. It's my pleasure to introduce Don MacOdrum, who I've had the pleasure of acting against in a variety of lawsuits and am currently acting sort of with in a current lawsuit. He is certainly a pillar of the IP community, a guest lecturer at the University of Windsor Faculty of Law, and an all-around brilliant guy. So Don, without further ado, let's what's new in patents?
They got me wired up here, so. Well, 2003 didn't have quite the excitement of the year before when the Supreme Court came down with the Harvard Mouse and the AZT decisions. And we had a little bit of excitement involving the Dutch Industries matter, which I'll deal with in a minute. Oh, this sounds pretty loud to me. But apart from that, there wasn't real excitement in the area, but there was a lot of litigation. There were a lot of decisions, dominated to an extent perhaps more last year than any other year by the pharmaceutical cases, and particularly the NOC cases. And so in this paper, which despite the unexciting nature of the law is pretty long, you'll find that there's a lot of pharmaceutical cases included in here. And that's just the way it was. No real legislative changes in the Patent Act this year. Legislation is forthcoming, as I'll discuss later on, in relation to the fees. There was a change in relation to the federal court that changed the names of the courts and the sort of setup of the court. So we now, instead of having the Federal Court Trial Division, have the Federal Court and the Federal Court of Appeal, each with its own Chief Justice. But apart from that, nothing really exciting. There are promises for next year. There are, or this year, the Supreme Court of Canada has given leave to appeal in 2 patent cases. One, the Biley's case, which is involves interpretation of Section 5.1.1 of the NOC regulations, this will be the first time that the Supreme Court has had a look at these NOC regulations, which, as I say, have over half of the IP cases litigated these days are NOC cases, and this will be the first time the Supreme Court of Canada has a run at these regulations. Pretty narrow point in issue, but we'll see what they come up with there. And the other is the Monsanto and Schmeiser case, in which they're going to have another run at patentable subject matter, possibly, this one dealing with plant gene patents. And there's also the very interesting question about infringement and sort of inadvertent infringement, whether Mr. Schmeiser's activities were inadvertent or advertent. I think that Monsanto and he might debate, but the concept is very interesting, particularly where you have the possibility that patented genes, contaminated, non-patented product, and really makes it almost impossible for forever not to infringe now. There was an injunction granted in that case that was sort of intention-driven, but now that he's been found to have the gene in his system, I'm not sure he'll ever be able to get it out. So there'll be interesting questions coming out of those two cases. As I mentioned, the legislation, and so I'd like to turn to the substantive issues, and I've addressed first the question of construction of patents. Now, I apologize for the format of the paper. There's a lot of typos or some formatting problems. This thing got put to bed at the very, very last minute in the final analysis, and so I bear all the blame for that. I had a lot of notes and so on from Dave Morrow, which I coordinated, but all of the errors here are mine. One of the issues that sort of got confused, at least in my perspective, by some of the courts this year was the question, and it's always a difficult question, as to what are the rules relating to reference to the disclosure in the construction of a patent. And I had sort of thought that things had been pretty well sorted out by the Court of Appeal in the Nakuska case several years ago, and by the Supreme Court of Canada in the Whirlpool and Camco case. But in the A.B. Hasley decision, the Federal Court of Appeal reverted back to Dabley and Ontario Hydro, and which paraphrased an earlier decision of Mr. Justice Urey in the Court of Appeal, and which said that you can only refer to the disclosure if there's an ambiguity, but he went even further than that and said he didn't even take the full statement of the Dabley test and put it in a fairly narrow frame. Now, it may be that in that particular context they did in fact apply the law the way it should have been applied, but the statement of the Court of Appeal in Hasley, I think, is problematic. Surprisingly, in another case by the Supreme Court, by the Court of Appeal, they, I think, put the matter absolutely right, and that was in the MI Drilling and QMAX case. And that is that the first thing you do is you read the whole of the patent, and you construe the claim and give it a purpose of construction in the light of the patent, but you cannot, once you've got the thing and you understand what it means, you cannot change plain meanings of the words where it's absolutely clear what was intended. Now, it's easy to say that rule, but it's interesting to see how it played out in practice. Another issue that was considered was the question of the extent to which you can refer to subsequent technology. And in this case, the GlaxoSmithKline and GenPharm case, the issue related to a claim for crystalline peroxetine hydrochloride hemihydrate. And the issue was, how do you detect that material? Can you use detection methods that were not disclosed in the patent? Can you use detection methods that weren't even known at the time of publication of the patent? Allied with this was another issue, was how much crystalline peroxetine hydrochloride hemihydrate did there have to be there? And that was sort of tied in with the issue. But on the question of what can you use to detect this, the argument was made. The Supreme Court of Canada in Whirlpool said you construe them at the date the patent application was published, or in this case, the date the patent was granted, where it's an Old Act case. And so you're limited to what was known then. Madam Justice Heenahan said, no, I'm not buying that, and said that you could use anything that would, as a matter of fact, show what the material was. Now, as I say, in that case, there was a question of how much of this material had to be in a compound in order to make it infringing. Was it enough that there were minute quantities? Would that make what would otherwise be old material infringing? And Madam Justice Heenahan concluded that if you give this claim a purposive construction, there had to be enough to fulfill the purpose that was outlined in the patent specification, which in that case, what was the purpose? There was apparently the hemihydrate improved the handling qualities of the product, and so she said there had to be enough that would give you this improvement in the handling qualities of the product. You just couldn't take a minute amount. And this was driven by two things. One, the teaching in the patent of the utility, and the other, the fact that there were old material around that might well have trace quantities. So those two things on a purposive construction led her to reach that conclusion. Another point on the question of purposive construction that was raised in another case, also a NOC case, was the question of avoidance of invalidity. This also was related to peroxetine hydrochloride, a different patent. It related to a dry formulation patent. And in this particular case, I've reproduced the claim at page 7 of the materials. You'll see it said a peroxetine formulation, which is prepared on a commercial scale into tablets using a formulation process and so on. Now, the question was, what was meant in that claim by peroxetine formulation? The plaintiff, or applicant, said it means any peroxetine formulation, even though in the patent application only the hemihydrate was included. And the question was, did it include other salts such as or other crystalline forms such as the anhydrate? Mr. Justice Kellen concluded that it was limited to the particular form that was disclosed. So he read into this claim a limitation to the hemihydrate, and he did that for a couple of reasons. First of all, he said, we're not bound by the dictionary meaning. The applicant had put forward the Merck index, and he said, we're not bound by that. He said that if the claims were given the broad interpretation, which you might guess would be applied on first blush, then the claims would be broader than what was invented, because this hemihydrate in this particular patent and in this particular formulation was said to avoid some pink hue problem, and there was no indication that this problem occurred with any other form. And so he said if if you gave it the broad interpretation, it would be going beyond the teaching. And also, he said it wouldn't have utility because nobody would use it. So because giving it the broad interpretation would render it invalid, he concluded it should be given a narrower interpretation. Now, this is a case, for sure, where words which on their face look broad were read down in light of the disclosure. Now, whether that's in accordance with the teaching of Whirlpool and Camco, I'm sure the Court of Appeal may well get to determine, because most of these cases get appealed, or a lot of them do. So, but that was definitely a case of reading down. One of the topics that I've flagged in the paper, and one of the things that I really feel is a problem we have these days, is the question of appeals in relation to construction issues. As you know, in the United States, the Court of Appeals for the Federal Circuit, which deals with all patent cases, has taken a de novo approach to patent construction, and they will relook themselves at issues of patent construction. Now, this is, I'm sure, in part driven by the jury system they have down there, but that's the approach that they take. In Canada, we haven't quite had that. But we had an interesting comment by the Federal Court of Appeal in this A.B. Hasley case, in which Mr. Justice Rothstein said, claim construction is a matter of law, and he cited Whirlpool. This court must therefore determine the correct construction of Claim 1. And I would say, yeah, I agree with that. But that's not what the Court of Appeal actually does in most cases. Giving you an example, in the NORAC case, which I've also referred to at page 9 of my paper, the Court of Appeal, after looking at the interpretation given by the trial judge to certain of the phrases in determining that there was no infringement, said, while this may have been a rather restrictive interpretation of the patent, it was open to the trial judge to so find on the facts of this case, and that finding should not be disturbed. Now, how does that jibe with the comment in A.B. Hasley that claim construction is a matter of law, and the Federal Court of Appeal must determine the correct construction of the claim? I just don't see it at all. Anyway, the NORAC approach is much the more common by our Federal Court of Appeal. I would like to see that change, but I'm not holding my breath. Now, on the issue of infringement, turning away from construction, but was driven a lot by construction, you can see what happened in 4 appeals. In every case, the finding of the trial judge was affirmed. In the NORAC case, it was affirmed based on the construction of the patent, as I've mentioned. That was involving a tension load cell. In Elmacon and Anchor-Tech, the parties had agreed on the construction, and so that wasn't the issue. It was a question of whether there had been a sort of a miscarriage by the judge's adoption, really, of some very clever expert evidence put in by expert witness for the plaintiffs. In this case, the plaintiffs had a mechanical engineer, Mr. Anderson, who had drawn some diagrams of the seismic plug that was in issue there, but he had done side-by-side comparisons, but he had taken parts of them and moved them, and so it actually redesigned the plug and said, oh, but if you take this part and put it there, it's the same, and so they are the same. The defendant was complaining about the use of this evidence, but the Court of Appeal said no, the judge was perfectly available to consider that in determining the question of infringement and finding assistance in how the plugs work in fact. The Illinois and Cobra case was another area where the issue was determined on the facts, and so was the MI drilling case, which I'll come to later. They found that there was infringement, as the trial judge had found, but they said that the plaintiff couldn't sue for it, and we'll talk about that in a minute. In the federal court, we had several cases, a couple of NOC cases, which I've already talked about, and then the Canna mold and dry angle case, which related to an apparatus for making a decorative molding that had a foam core and a pre-applied coating. This turned again on the question of construction of the patent. The table included the claims include language that the table be flat. The defendant's table had a trough that was involved in the construction. That was the end of the infringement issue. In Alberta, the Polanski case went back, or the decision came back on this case. This was a case that had originally been tried, I think, in 1999. And the trial judge had found the patent to be valid and infringed in a sort of a strange decision. I think it was Mr. Justice Lesfrud. And he had awarded damages and punitive damages, as we'll see. This went to the Court of Appeal in Alberta, and the Free World decision had just come down before the appeal decision. And the Court of Appeal said, you really didn't address the question of the construction of the claims properly at all. You didn't really address the construction of the claims. And they sent it back, and they sent it to a different judge. And this judge, Mr. Justice Clark, did do a construction of the claims, and he found that the product, which was an interface device to allow faxing to a mobile radio like a Palm Pilot, was there was no infringement because essential features of the claim were not included, and so completely different result from the earlier trial, but turned essentially on the facts of that case. In that case, on the remedies issue, I think the interesting point is the question of exemplary damages, because the quantum of damages otherwise were agreed. Now, there weren't actually damages awarded because there was no infringement, but there had been evidence, and so the judge made a finding on these issues in case he was wrong on it. But on the exemplary damages point, whereas $100,000 exemplary damages had been awarded originally for knowing infringement of the patent, even though there was very strong non-infringement and invalidity defenses, Mr. Justice Clark looked at the Supreme Court of Canada decision in Sylvan Lake, which sort of paralleled with the Witten case in the Supreme Court of Canada, and the principles that were outlined in those cases, and said you've got to have outrageous, oppressive, high-handed conduct, and there's nothing like that here, and dismissed the award. And I think that's the way things go. This Polanski case was sort of an anomaly in patent cases for an award of punitive damages, and I think it was properly put right. Now, turning to the matter of validity, the case of MI drilling and QMAX involved a patent relating to a drilling mud. That's stuff they use to send down the drill hole to bring back the cuttings and so on. And this was really, I think, the first time that the Federal Court of Appeal has looked at the test to be applied in a new act obviousness situation. We've had the obviousness section around since 1996, but this was really the first time the Court of Appeal had really addressed it. And so it was interesting to see, not surprisingly, that they looked to the old law and with the amendments as to the time frame. But I think that it will be interesting to see how this progresses in the future, where people look more closely at specific issues in relation to obviousness. There's a lot of parroting of favorite statements from Beloit and from the Baer and Apotex case we see these days. And I'm sort of hoping that sometime the court will take a hard look at obviousness the way they did a couple of years ago at anticipation under the new act when they came in that Baker and Canwell case. But we didn't get that in this case, but this is at least a statement by the Court of Appeal of the principles in relation to the new act. Just in terms of parroting the principles, we've seen that Madam Justice Dawson in the Pfizer and Apotex case last year, or in 2002, did a sort of a review of the principles, citing Beloit, citing Baer and Apotex, citing the decision of Mr. Justice Whetstone in the AZT case. And three of the judges really seemed to like this statement of principle. Two of them, in the Baer and Apotex and in the A.B. Hasley and Genfarm case, basically simply said, Madam Justice Dawson said it all, I adopt that as my own. And in the Canwell case, this case was also cited as, along with two others, basically as setting out the principles. Now, this is fine. Actually, I think that there was a pretty good statement of the principles as far as it goes, and on the particular issues that were being addressed there. But I do sort of concerned about just getting in a sort of a lockstep parroting, so you're going to be all right on the Court of Appeal, and then everything else is an issue of fact. But that's... So there were a number of obviousness cases decided on the facts. I've referred to them in the paper, and I've tried to include some of the reasoning that went behind them so that you can understand what the points were that were considered significant. And I'm not going to spend a lot of time here going through these. You'll see that in the Canna case, for example, which is one of the areas where my formatting went all wrong on my, the judge was critical of the defense expert as not really being in touch with the knowledge of the skilled worker. Well, if she finds that, then you know you're dead. Also concluded that what the expert did in that case, which was a combination case involving that apparatus I mentioned, was a dissection of all of the elements, and that's a no-no in a combination claim. You got to look at really whether there was an impetus to put them together, and she didn't find that. In the GSK and Pharmascience, this is an interesting case, an NOC case, but nevertheless very, very interesting, because this is one of the few cases in the past year in which a patent was actually found invalid for obviousness. And this was a case involving the use of a particular medicine for the treatment of congestive heart failure. And there had been literature suggesting this use. And there had been some test results that indicated that it was probably going to be successful. But there had not been the final tests with humans to show conclusively that it was effective. And the argument was, well, this is nothing more than a worth-a-try situation, and there's no obviousness here. But the court said no. They said there was enough here to point people not only in the direction, but to tell them that it would probably be successful, and that there was no inventiveness in simply confirming that expectation. And so the conclusion was that the art led directly and without difficulty to the invention, and it was obvious. Well, this is an interesting case. I think the one that if you're involved particularly in any kind of chemical situation, this case bears good looking at if you're dealing with an obviousness issue. There were several other cases in which the obviousness allegation was found to be not justified, i.e. that was dismissed, and I've listed them there. And they're dealt with in more detail, considerably more detail in the patent, in the paper. But I'm not going to go into them in detail here. I just will mention that I apologize particularly for the discussion of the A.B. Hasley and Genfarm case on page 20. I was working on this about, I guess I got to this about midnight one night, and I said, all right, there's 4 patents, so I put down 4 patents, and then I started through the first 2 dealing with the obviousness issue there, and then I came to the 3rd one and started dealing with it, but what it related to, and you'll see that it just tails off. There's no discussion. Well, the fact is that the issue didn't actually deal with obviousness in that case. It was non-infringement. So then I flipped over and started dealing with that issue, but I forgot to take out what I'd already written. So you can just delete that last sentence on that thing because there was no obviousness issue in relation to the other 2 patents. So I apologize for that sloppiness, but that's just my late night activities. On the issue of anticipation, we all know what the test is. You have to have a full disclosure in the art. It's got to be the teaching of the invention. There was anticipation raised in a couple of cases. In the GSK and Apotex case, this was a sort of an interesting case because the prior publication was a former GSK patent. It did teach the use of this particular formulation using a dry process, but it didn't actually specifically say that you didn't have this microcrystalline cellulose. And the claim in issue said a dry formulation where microcrystalline cellulose is absent. So the reality is you probably never find papers that say we don't have this in it. But the court found that there was a teaching to make the dry product, and that because microcrystalline cellulose was hygroscopic, if somebody wanted to make it dry, nobody would include it, so that they put the paper together with the common knowledge of the skilled worker and found anticipation. Now, the GSK and Genfarm case is an interesting case. This was a case involving the old Act, and there were 2 grounds of attack. One was under Section 27(1)A, which, as you recall, is a question of prior knowledge or prior invention, but has to be combined with Section 61, which says one of the grounds is that it be disclosed in such manner to be available to the public. And the court made an interpretation of what constitutes making available to the public, and that's interesting because that language is also used in Section 28.2 and Section 28.3 of the new Act. And in this particular case, there was said to be a teaching in the prior patent to make this particular formulation, but it didn't specifically disclose the actual chemical structure. And the court held that she said, I do not accept the argument that as long as the public is aware of the existence of the end product, then knowledge of the product's composition is immaterial. And she distinguished the Merrill Dow case in which, that dealt with the metabolite. Well, of course, I don't know the facts as they actually played out in that case, but as a general statement of principle, I think you've got to be very leery of it, because I think the law is properly stated by the Court of Appeal in Baker and Canwell, and that is, and going back to the old case of Stelwerk Becker, that if you can make an analysis of the product, then it is disclosed in a way to make it available to the public, if it can be done on the equipment existing at that time. So I just say in the paper to compare this approach with the Court of Appeal in Baker and Canwell. The second issue was a question of anticipation by prior publication under Section 28(1)B of the old Act. In this case, there was evidence given of a repeat of the invention, and the court wasn't convinced about the repeat, but the big issue seemed to be that evidence by from the patentee that you could actually now never repeat the old material because seeding from the hemihydrate would always cause you to get that form, whereas before you would get the anhydrate. I don't know enough about the chemistry to know how that works, but it sounds like an extraordinary proposition to me that you could avoid ever having an anticipation because your new material corrupted all the prior art. Just doesn't sound right to me, but I don't know enough about the technology. Double patenting, you'll recall, was obviousness double patenting comes out of Whirlpool and Camco. It was applied in the GSK and Apotex case. It was argued in that case that it only applied really to old Act cases, that the new Act cases avoided the sin of double patenting because the patent term ran from the filing date. But the court said no. Having multiple patents for the same invention is a bad thing, and he said we can see example of it right here in this NOC proceeding because it gives you an automatic injunction. So that's one of the things. And in any event, they said you shouldn't get multiple patents for the same invention, and in that case they found that there was the same invention and held it invalid. Now, I guess you might have thought that the question of wrong inventorship as a ground of invalidity had been sort of put to bed by the AZT case, in which they held that you had to have fraud for wrong inventorship to be a ground of invalidity. And indeed, in the MI Drilling and QMAX case, they found that they were bound by the Supreme Court of Canada AZT to hold that the wrong inventorship, which had been found by the trial judge, could not render the patent invalid. In this particular case, it was a small family-owned company. There were two brothers who were the driving force of the company. The company developed a new mud. They had been named as the inventors. The trial judge found that a chemist who had been employed by the company was the true inventor. Apparently, he had been contacted at the time of the patent application and wouldn't participate. There was the court found no bad faith in naming the two owners as inventors. They were intimately involved in the business. But the trial judge held the patent invalid. Court of Appeal said no, it's valid. But, strangely enough, they said that because these people were found to be not the inventors, therefore they could not give good title to the people they assigned it to. Therefore, they also couldn't give a license to the company that was their employer, and so the company ultimately became the owner of the patent, the registered owner. So the end point was that the registered owner of the patent that was expressly found to be valid couldn't sue on it. Now, the plaintiffs are seeking leave to appeal in this case. I have slight bias on this. We act for the plaintiff. So I declare my bias, but I'll leave it to you to consider whether that's a strange result or not. Dutch Industries, we all know, has caused a huge furor in the industry. The trial judge found 2 patents invalid because proper maintenance fees had not been paid. They paid as a small entity. They were not a small entity because of some licensing arrangements, and that was the patents were held invalid. The Court of Appeal last year reversed that in one regard, but not other. They revisited the issue and said that you make a determination of whether you're a small entity or not at the time you first become involved in the patent system. For most people, this will be when they apply, if the company remains the same throughout. And so the status doesn't change. So even if you later license it or later become bigger, your status doesn't change. It's fixed once and for all. Well, the government has decided to bring in retroactive legislation. Just parenthetically, I think it's sort of interesting that they decided this now. They didn't actually care when the trial judge came, even though this was causing great trouble for everybody in the business. And they said, oh, well, this is the patent profession's problem, not our problem. It's only when they saw that if people were actually having their position determined at the time of the application, they might lose out future fees, that they decided that they better act. I think it's sort of nutsy myself. I couldn't believe that they didn't act originally. But anyway, they now have acted. They announced in the summer that they were going to do retroactive legislation. This legislation is now posted on the SIPO website. I've reproduced it here at page 130. They've invited comments, I think, up till the end of March. So if you take a look at it, this is what they're going to have. The actual saving provision, though, for old Act stuff, I think is a little bit short. That'd be my only comment, but I haven't gotten around to submitting comments. I've referred to a case that dealt with a competition law issue at page 131, but I'm not going to talk about it. I'd just like to briefly touch on a couple of summary judgment cases. Ron Dimock had a great idea, at least he thought it was a great idea. I'm not so enamored of it myself, of bringing a Markman type proceeding in a case to get a preliminary determination of the construction of the patent. This was in this Real Search and Belloni case, and I won't say much about this because apparently the Court of Appeal, I was talking to Ron yesterday, that the Court of Appeal has reversed this, and so we'll hear all about this next year. But I'm not, so I wouldn't put your stand on that. The other one that was just as a bystander found sort of surprising was this Trojan and Suntech case involving a patent for UV water treatment, which there was summary judgment of patent infringement and validity granted over conflicting expert evidence as to the construction of the patent and other issues, and particularly on the issue of validity, it seems that there was evidence of a facility in the United States that was great stock was put on by the defense as a anticipation and as a basis for the claim for obviousness, and on the basis they put the anticipation really as a prior invention, but it's sort of the same thing. And the trial judge found, or the motions judge found, that there wasn't sufficiently proved, so there was no invalidity, and that the parties had their obligation to put their best foot forward, and this wasn't best enough, so tough beans. Well, I just think there's something wrong about determining issues like this on a motion for summary judgment. It's difficult questions of fact and issues of conflicting expert evidence on affidavits and cross-examination transcripts on a motion. So we'll see what the Court of Appeal does with it. There was a motion for stay, which I've mentioned at the pages 35 to 36, in which Mr. Justice Linden granted a stay and said there is a serious issue on this question. And I think this is more than serious issue. I think this is just dead wrong. But, you know, what do I know? I flagged it on page 36, a case, Apotex and Merck, in which the Court of Appeals said that the case management rules, which gives the notary or the case management judge a right to give directions to move the cases along, don't override the rights in relation to examinations for discovery. There are situations in which discovery can be limited in proper cases in accordance with the rules, but they are not, those rules aren't overridden by the case management rules. An interesting decision, I think. And the other, there's a question of cost. In the Illinois and Cobra case, the trial judge had said, we're not going to give costs because although the defendant won on the issue of non-infringement, they had also raised invalidity. It hadn't succeeded on that point. Court of Appeals said, no, they were the winner. There was an action brought against them for infringement, and it was dismissed. So they should get the costs. Now, I'm not going to spend a lot of time on the NOC regulations. It's sort of a specialized area for people, but I just will touch on a couple of points that are of interest there. And one is the question of non-infringement for a different use. What happens is that if you can, there's no question that you can have a patent granted for a second medical use for an old chemical. You can have that, of course, for a second use for any other kind of product in a proper case. The Supreme Court of Canada said this in Shell Oil. But this is very common in the pharmaceutical area, to get a second and third medical use for an old drug. And the question, however, is what happens if the generic company wants to make and sell the drug for the old use? Can the fact that it may get used for the new use preclude it? And there were conflicting decisions of the Court of Appeal a year ago. Gen Farm, which was decided in the summer by the Court of Appeal, and then the A.B. Hasley case, which came along in the fall. And we had another conflict this year, now at the trial level, between the Lundbeck's pair of decisions and then this A.B. Hasley and Gen Farm case, which came along right at the end of the thing. Now, this is actually, they involve questions of infringement, but they also involve questions of interpretation of the NOC regulations. Because what was said in Gen Farm was that even though the generic company has applied for an NOC for the old use, and it's not applying for the new use, they found that, that they didn't actually find there would actually be direct infringement by the generic company. Nevertheless, there was a finding that patients would use the generic product for the new use, and that was enough under the NOC regulations, which were said by the judge to prohibit infringement, period. Going back to what had been held in the earlier Gen Farm case a year ago, to stop it. As was pointed out in the Lundbeck case, this kind of approach raises a serious policy question if you can use a new use to stop people making the old product for the old use. So this thing is still going on. And there's continuing fights over the patent list, and one of the issues relates to linkage, whether the patent actually has to correspond with the drug that's on the market. The Court of Appeal said no. And finally, there's this question of when do you have to deliver an NOA? The NOC regulation, Section 5, the original idea was that if you were a generic company and you referenced the earlier product and therefore didn't have to make the full submission to the Health Canada, that the trade-off was you had to file a notice of allegation in respect of any listed patents. Well, somebody tried to get cute and do an end run around that, and so Section 5.1 was included to put that to bed. But the court held that it wasn't limited to situations where there was an abbreviated new drug submission. If you actually had to do a formal new drug submission in relation to something that involved the same medicine, then you were caught. Now that case actually related to the very same chemical, which had exactly the same chemical composition, although they came from a different source, I don't feel so strongly about that issue. But this section has now come to be used by Health Canada. They're terrified of this Court of Appeal decision, apparently, and they've applied it in situations where there's been a sort of a category name for a medicine, and the medicines may actually have different chemical structures, but they say, and the category name may be old, really old, and nevertheless, if that category is covered and that's the way the thing is framed, then you're precluded. Supreme Court of Canada has given leave in this. I hope that they take the opportunity to address the broader implications of this section, but we'll only wait and see. And that's it. I've got 4 minutes, I think. Well, no, I'm not according to this clock.
Yeah, we'll give you a couple of minutes for questions. Are there any questions from anyone here?
Okay, thank you. I apologize to the other people, but I've got to run for an examination for discovery.
Thanks very much, Don. Sheldon, you're up next. Sheldon is a partner at Blake's here in their Toronto office and is a prolific author and speaker. And Sheldon, if you're all set to go, I'm going to let you start. I think it's 15 minutes.
50, okay. That's great.
Put that on a piece of paper.
Yep.
Double check.
Okay.
I'll rate your hand time.
Just while Don's unplugging, my watch has gone on the fritz, so I brought an egg timer, which sounds like the 60 minutes clock. So at some point, if I confess to gambling on baseball, you'll know why. Every year I show up and I'm constantly amazed at the turnout. This is wonderful, and I tell this story for those of you who've been here before, have heard this before, about how, I guess it was 8 years ago, somebody at the Law Society asked me if this would be a good idea, and I said no, it would never work. Because there were too many other things. Obviously it has. And I think in part it's worked to guys like Don who, I think there's nobody in the country who is more knowledgeable about patent law than Mr. MacOdrum.
Oh, I thought you were talking about this, Don.
I should have quit while I was ahead. My topic is, as has been the norm, copyright and design legislation. I don't have a PowerPoint, but there are two things you can do. The easiest thing might be to pull out the table of contents, which is quite detailed, and use that as we go through this. That'll effectively serve as a series of PowerPoint slides in hard copy. I will, as Don and all the other speakers do, focus on some aspects more than others because you'll appreciate there's a lot of material to cover. Another point I made about 8 years ago was that copyright probably couldn't really cover a full session. It was sort of a little bit player at the time. Well, that too has changed dramatically. One last point, I should thank my co-authors who really bore the brunt of the work this year. George Fisk, my partner in Ottawa, who's presenting this in Ottawa tomorrow, and one of our Ottawa students, Alexandra Budgell, who really did the lion's share of the work. So I want to acknowledge that. 2003, it's really been a transitional year. And quite frankly, while there are a number of things of interest, 2004 promises to be a far more interesting year. And if I'm invited back, will mean a lot of work. The reason being, the Supreme Court has granted leave, and in two decisions of the Federal Court of Appeal, and in fact, those cases were heard in late 2003. They are the CCH library case involving Law Society and the Tariff 22 case. as well, parliamentary hearings and a committee report on the performance of the Copyright Act after the 1997 amendments were supposed to occur in 2003 and were deferred until next year. That having been said, there was a fair amount of stuff to report on for 2003. Firstly, there was a Supreme Court of Canada decision in Despoteaux which clarified the role of an arbitrator and commented on moral rights. There were a couple of appellate decisions, one on the law relating to photographs and another one on the degree of deference to be accorded by the courts to the decisions of the Copyright Board. And recently, the Copyright Board handed down a very important decision in the private copying tariff case. Let's start with the treaties. In 1996, two WIPO treaties, the Copyright Treaty and the Performances and Phonographs Treaties, were adopted. They were ultimately ratified in 2002 when the requisite number of signatories signed on. Canada has not ratified yet. And the Minister of Industry said the Canadian government would not rush into ratification. One of the reasons is that the treaties provide for requirements to protect anti-circumvention measures, which we'll talk about later. And so that is one factor creating the hesitation on the part of the Canadian government. The Act. There were no large-scale reforms. Bill C-11 came into force in March. We'll talk about more about that bill later. That clarified compulsory licensing of over-the-air radio and television signals is available, but only to cable and satellite distribution systems. For example, not to internet distribution systems. I mentioned the report on the Copyright Act. Section 92 mandated a report by late 2002. That report was tabled in October 2002, and a parliamentary, and in fact, I discussed it at some length because it focused and prioritized issues over a period of short, medium, and long term. And a parliamentary committee was supposed to review that and report back to Parliament. That committee report is now not due until June 2004. We saw another highly publicized copyright bill, Bill C-36, which made the papers often referred to as the Anne of Green Gables or the Lucy Maud Montgomery bill. That's because, as part of the copyright reform in 1997, the period for protection for unpublished works was shortened from perpetual protection to life plus 50 years, very much like other works. And there were transitional provisions which were introduced relating to unpublished works of authors who died before January 1, 1949. The works covered by the transitional provisions would have had copyright expire on January 1, 2004. As that date approached, a number of authors and estates got concerned and got introduction of Bill C-36, which would have extended that term in some cases, and there were a series of terms, in some cases as long as 2017. The bill passed first and second readings in the Commons, was amended prior to third reading, which resulted in a compromise position which would take protection until 2006, and then passed first and second reading in the Senate, but died when Parliament was prorogued in November. The result is the bills are died, the works have fallen into public domain in January, and the question, and absent some sort of retroactive legislation, which of course would be tricky, though copyright in those works may well be toast. What this legislation, well, the legislation raises a number of questions. Query whether it was special interest legislation, but also query whether this foretells the possibility of copyright term being extended generally. It's odd because copyright has a fairly long term as compared to, for example, patents. And in the old days, the idea was that authors didn't reap the benefits of their work for a long time. The reality is, in the modern era, authors reap the benefits of the work far more quickly. There are exceptions, but commercialization of works generally takes place more quickly than it did hundreds of years ago. And the U.S. yet the U.S. has extended its copyright protection to life plus 70, and that was recently upheld as valid in the Eldred and Ashcroft case decided by the Supreme Court, U.S. Supreme Court last year. So we may see a longer term of copyright. Bill C-20 relates to copyright in photographs. As you probably know, there is a special regime for copyright in photographs in the Act today. The owner of the tangible negative, plate, or original photograph at the time it's created is deemed to be the author and therefore is deemed to be the first owner. It's subject to an exception where a person who commissions a photograph and pays for consideration and pays the consideration is deemed to be the first owner. The net effect of that is a professional photographer who takes a commissioned photograph and is paid is not the owner of copyright. Rather, it is the subject of the photograph who is paid that is the owner. Well, photographers for a long time have been quite upset about this, and they introduced Bill S-20. And it proposed amending the law so that the photographer would be treated like any other author and would be the first author and therefore would be the first owner. That bill made second reading in the Senate, but also died when Parliament was prorogued, so who knows if that will come back. There were a few minor amendments to the copyright regs. The really only materially relevant one is the fee change. Interestingly, in some cases, fees have been decreased where the service is going to be requested online. Proposed amendments. There is a proposal to make changes to the local and long-distance signal regs. These relate to the retransmission rules, and the rules would say that the signals which currently apply to cable systems would equally apply to satellite systems. And there was a deadline for public comment in September, and we're sure to hear more about that. Another topic which I've dealt with year over year is the interface with broadcasting law. There's significant interaction in many cases among the Copyright Act, the Radio Communications Act, and the Broadcasting Act. And particularly in the area of broadcasting communications, obviously, as evident in cable and satellite. But emerging technologies are raising issues among these three acts. Last year I reported on the decision of Bell Express View of the Supreme Court of Canada, which held that the Radio Communications Act prohibits the decoding of all encrypted satellite signals unless the signals are acquired from a lawful distributor being lawful under the Copyright Act. And so in response to that decision, the Ministers of Industry and Canadian Heritage announced their joint intention to amend the Radio Communications Act to further combat DTH, direct-to-home satellite television services. And what they've proposed is better control on the import of illegal telecommunications or radio communications equipment, increased penalties for satellite piracy, and a strengthening of the ability of the broadcast industry to assert civil actions. As well, there has been a committee ongoing for a couple of years of the Canadian Heritage Committee looking at the Canadian broadcasting system. And in June, it released its report. And a number of the issues raised in that report could impact copyright. One, the committee recommended the creation of a single Department of Communications which would govern broadcasting, telecommunications, and cultural industries. So that might scoop copyright into that department. Secondly, the three separate acts, the Broadcasting Act, the Telecommunications Act, and the CRTC, the Canadian Radio, Television, and Telecommunications Act, all govern related aspects. And it was recommended that there be a single new Communications Act which would sweep those all within a single umbrella. The government also, the committee also recommended a review of the CRT's mandate and a clarification of its roles and responsibilities. It also touched on the issue of copyright in the context of new media, and particularly focusing on the exemption order that we'll talk about in a few minutes. But The committee stopped short of dealing with this issue because the CRTC has a regular review, and particularly that exemption order is scheduled for review in 2004, so it deferred consideration on that issue. Okay, which leads right into the next topic of the internet. It's worth noting a trademark case, ITV Technologies and WIC, where the court said the use of the internet as evidence in trial is a good thing. The court can benefit from viewing the internet as opposed to paper copies of websites and things, because it can look at how hyperlinking and streaming and meta tags and all the things we do on the internet work. And it also proved the use of a website that allows that archives earlier material. And to the same effect was a decision of the Patent Appeal Board in a design case. So we're going to see more and more live use of the internet in court proceedings. I mentioned Bill C-11. This is the one that excludes, which was enacted or received royal assent in March. This is the one that excludes retransmitters from the compulsory internet retransmitters from the compulsory licensing regime. It was first introduced in 2001 and was really meant to deal with the iCrave TV, Jump TV, and related situations. But the way it operates is somewhat circuitous. The way it carves out what are called new media, or new, i.e. non-satellite and cable media, is to exclude a defined term, a new media retransmitter. And a new media retransmitter is defined as a retransmitter whose retransmissions are lawful under the Broadcasting Act by reason of the exemption order for new media broadcasting undertakings issued by the CRTC. So in other words, the access of internet retransmitters to that retransmission right, it depends entirely on whether the CRTC amends or eliminates the exemption order. Now, the exemption order was issued in 1999 and was not scheduled to be reviewed until 2004. But the federal cabinet in late 2002 asked the CRTC to review the order and see whether it should be amended. January 17, 2003, as I recall, was either the day of or day before or day after last year's presentation, the CRTC published its report concluding that the exemption order should stay in force for the time being. And the reasons it gave was that the new media are not currently a substitute for convention over-the-air broadcasting, and that there's really no way to ensure that internet retransmissions are contained within Canada. So basically they said, look, we don't want to get near it for a while, but it's going to come up again this year, and that will have a number of implications. Okay, let's talk about more of the cases, and as I said, I'm going to skim some. Firstly, no copyright attaches to an examination for discovery and its resulting transcripts. That's Sterling and Sullivan. Secondly, a summary of bids received in response to a request for a proposal is prima facie entitled to copyright protection. That's the Fraser Health Authority, and that's because the memo was a compilation which was likely to have been achieved through skill, judgment, and labor. Bonds and Suzuki was a sort of an oddball case. The plaintiff claimed that Suzuki made a vehicle based on the plaintiff's drawings. The court said copyright can't be asserted against a useful article such as a vehicle, and also said that where similarities arise from non-original features, in other words, the features that were similar were broad and not particularly unique or original, there's no infringement. There were a bunch of interesting cases on authorship and assignment. And for those of you doing commercial work, I think these are fairly important. Firstly, on authorship, there was a decision of the Canadian Artists and Producers Professional Relations Tribunal. That's a board under the Status of the Artists Act. And if you've been here the last few years, you will have recognized that there are a number of cases coming out of that tribunal under that act. And in this case, it was held that joint authorship cannot be determined solely by reference to the intent of the parties. What happened was Editors Association applied to the tribunal for certification under the Act of a group of freelance editors. And to qualify, they had to prove that they're authors. And what the position they took and the position that the tribunal bought was that as editors, they are joint authors. The writers' union got the tribunal to reconsider that and argued that no, that's not the case. The proper test for joint authorship is that from Newdorf and Network, 2000 case, and what I call the Sarah McLachlan case, which I reported on a couple of years ago. And that, my comment stand was that case was probably wrong under Canadian law. It relied heavily on US law, and the US statute is different than the Canadian statute. The Network case said that for someone to be a joint author, they had to, one, contribute a significant original expression, and two, have the intent to create a merged work. Well, the tribunal rejected that test, and they said there was too much emphasis on intent. And the proper test is whether the editor had contributed significant original expression and had collaborated with the other author. Intent can be considered, but it's not determinative. On the facts, the tribunal conclude that the editors really don't collaborate. They perfect the work, but they don't collaborate the work. So it's interesting because Network, which is the most sort of recent court decision on joint authorship, has now been questioned, but it's been by a tribunal. So I ask you, what's the law on joint authorship in Canada? I'm not sure it's clear. Because there are other good bases on which to say Network is wrong, but it is a court decision. So I have a feeling we're going to hear about that issue soon. Again, ownership. I talked about the special regime, the current regime for ownership in photographs, and the Quebec Court of Appeal recently had to deal with that. Alice Roby commissioned, who apparently is was a well-known Quebec entertainer in her day, commissioned Desmarais, who was a professional photographer, to take her photograph. Roby, this was years and years ago, I think it was the 50s as I recall. Roby paid and received the photographs. Desmarais kept the negatives. Decades later, Roby allowed those pictures to be used in a biography. Desmarais' estate sued and said, hey, we own copyright, you're infringing. The court held that Roby owned the copyright and said it wasn't necessary for the subject to request a negative expressly in order for the exception to apply. You recall the exception I mentioned earlier. It's sufficient if the photograph is ordered prior to the production of the original negative. So that's very helpful to the subject or commissioner and hurtful to the photographers, and this case may yet fuel reintroduction of Bill S-20 to further protect or to try and get better protection for photographers. Academic works. In an interesting case, but it's hard to know how much weight to place on it because it's a Ontario Small Claims Court decision. It was held that a professor who authors academic works while working at a university owns copyright in the work. And Dolmage was a professor at Western, and he participated in a workshop, and for that workshop he authored a case study. And the university ultimately reproduced, published, and sold several thousand copies of the case study. Dolmage sued. Now the court held he was the only author. The defendants argued that the university owned copyright because, by virtue of subsection 3, the university was the professor's employer. The court said, and this is a perfect sort of example of my theory of litigation, that the court tries to figure out what they want to do, and then the court figures out how they're going to twist the law to get there. The court concluded that there has long been an exception in the university community that ownership of academic works lies with the academic. That's to preserve academic freedom. So this implied academic exception is an implied agreement to the contrary, because the law says, 13.3 says, works of an employee made in the course of the employee's activities for the employer belong to the employer unless there's an agreement to the contrary. So the court said this custom had the effect of an agreement. There it is. Assignment. 13 sub 4 requires that an assignment of copyright be written. But the court in Turgeon-Michaud said the written document, which serves as the assignment, does not have to be clearly articulated. In other words, there was a written document. It didn't assign the works, but the court said, oh, that's good enough. It's sort of like an assignment. Michaud hired Turgeon to write an article about Michaud's relative. He's a famous industrialist in Quebec. Michaud reserved the right not to publish the manuscript. Turgeon got all the derivative rights. The contract never dealt with who owned copyright. Michaud and the publisher first talked to, Michaud and Turgeon first talked to his initial publisher. Michaud ultimately decided not to publish the manuscript. Turgeon went off with another publisher and decided to publish. Michaud sought an injunction against the publication. Both the Quebec Superior Court and the Quebec Court of Appeal found in favor of Michaud, saying that the document, in light of all the circumstances, constitute an assignment of copyright to Michaud. And the assignment does not have to be explicitly articulated as long as the intentions of the parties are clear from the document and the surrounding circumstances. In this case, there were a number of surrounding circumstances that support that conclusion. Further support for my theory. Proof of assignment in that in the Dolmage and Erskine case, that's the U of Western Prof. The court said, although an assignment must be made in writing, such written document need not be produced at trial if the subsequent behavior of the parties is consistent with its existence. So now you don't need a contract that says an assignment, and by the way, you don't even have to provide the document at trial. So I think these are all attempts by the court to sort of reflect commercial reality and to deal with the provision in the Copyright Act 13.4 that says an assignment or a grant has to be in writing. And so what these cases say that if you're in a pickle but you have decent facts, you might still be able to set up an assignment. It doesn't, for those of you doing commercial work or advising your clients, I'm not sure you should dispense with the need for assignments. In the current economy, it's not surprising that we have a copyright case that deals with the interface between copyright and bankruptcy. And this is Rees Stewart House. And there the court said that the seizure power under 38(1) of the Copyright Act cannot be used to circumvent bankruptcy proceedings unless there is an infringement of copyright. In other words, unless the goods that are supposed to be seized or intend to be seized are infringing goods. What happened was Egmont granted to Stewart a license and distribution arrangement and also gave Stewart inventory. Stewart went bust. Egmont tried to seize the inventory ahead of the other creditors and relied on 13(1). The Ontario Court of Appeal said that these were legitimate copies. They weren't infringing copies, therefore 38(1) did not apply. And Egmont had to get in line with all the other creditors. It did not have a preference. Let's look at some infringement issues. Arbique and Gabriel. There, the court said a copyright holder must discharge a strong burden before a court will find that his work, or his or her work, has been substantially copied or appropriated. What happened here is Arbique developed the concept of a TV show and tried to peddle it to a network. The network said, no thanks. Gabrielle worked at the network. And lo and behold, a little while later, Gabrielle and some other people, she's no longer working at the, he's no longer working at the network, and Gabrielle and these other people go off and produce a show with the same title, the same basic premise, with slight differences in format and presentation. Arbique sues Gabrielle. Both the trial judge and the Court of Appeals say the plaintiff could not conclusively prove that Gabrielle had access to the plaintiff's work while employed with the defendant. So there was some doubt. As a result, the plaintiff failed. So that presumably turned on the evidence and may well have turned on the good guy, bad guy issues. Photocopying, I mentioned the CCH decision of last year that has been heard by the Supreme Court. Let me talk about technical protection measures, because I made reference to them earlier. Copyright holders have increasingly or are increasingly turning to technical protection measures, such as technology put into CDs, which will restrict copying in one way or another, machinery, but typically in the copies, also on watermarking, all those various things. The two WIPO treaties that I mentioned require that contracting parties provide adequate legal protection and remedies against the circumvention of technical measures. I mentioned that the government is hesitant to ratify the treaty on behalf of Canada. The Department of Canadian Heritage commissioned a study, and the results of that study, which was led by Ian Kerr, conclude that Canada should proceed cautiously because there is some concern that technical measures provide a greater degree of control to rights holders than traditional copyright law. For example, even where work is protected by copyright, there are exemptions, there are defenses. Private study, under fair dealing, private study, criticism, research, a variety of situations in which things can be done with works. But technical measures typically don't differentiate between what can be done and can't be done, so they may act as an absolute bar. Further, TPMs often raise privacy measures because they are often equipped with tracking and surveillance devices. So the government is currently grappling with that, and we're going to hear more. Next case on infringement relates to authorization. And a Quebec decision said infringement only occurs where the person purporting to give authorization has some measure of control over the infringing acts. This is Buchwald versus a numbered company. Buchwald hired a first web page designer to design a page. Didn't like what that guy came up with, went off and hired a second guy, told the second guy what the first guy had done, and in fact told the second guy how to get access to the first guy's work. The second guy allegedly took most of the first guy's work and copied it. The first guy sued the client, Buchwald, on the basis that by directing the second guy to the first guy's work, the client had authorized infringement. The court said that was not authorization, therefore not infringement, because the client didn't have any control, didn't approve or sanction. All the client did was provided the second guy with information. And in fact, the client was not aware that the second guy would intended to copy, and in any event had no means to control what the second guy was doing. So the client got off the hook in that case. Let's deal with some exceptions and defenses. I mentioned the CCH case again on fair dealing and library exceptions. We'll hear about that. And Tariff 22 I mentioned, we're going to hear about that in the context of common carrier, caching, and the like. Fraser Health said there's no public interest exception to copyright infringement. That's consistent with existing law. License. A license, even an oral one, is a bar to infringement. So again, in some respects, carving away from the requirement for writing in 13.4. Moral rights. It's interesting that the case I mention most often is a small claims court decision, and you haven't yet heard me talk about the Supreme Court decision. Dolmage and Erskine, this is the U of O prof again. The court there said it is an infringement of an author's moral rights to associate him with the work as something less than an author, unless there's consent. What happened here in these publications, subsequent publications of the work by the university, the professor's status was progressively downgraded. First, he was identified as an author, then as a co-author, then as a preparer, and then as nothing at all. You can see this relationship was probably going downhill in a hurry. Anyways, the court said his moral rights were infringed when all the stuff was occurring on the materials. Interestingly, they said there was no violation of the moral rights because his name was left out of the catalog of their works. And in awarding damages, they said you have to look at the plaintiff's level of distress and the defendant's attitude. They said there was no malice, so there should be no punitive damages, but they recognized that publication is important to a law professor, and they award $3,000. In another moral rights case, if any of you are golfers, you might want to read Ritchie and Sawmill Creek. There the court said that the right of association to which the author is entitled only occurs where it is reasonable in the circumstances for there to be an association. The court also said that enlargements of photographs are not so markedly different from smaller versions as to damage the author's reputation. Okay, let's talk about the Supreme Court of Canada. Deputeau and Édition Chouette. Basically, the court said that although issues of authorship and ownership touch on moral rights, they are primarily economic in nature, and therefore the issues can be dealt with by an arbitrator as long as they're within the terms of reference of the arbitrator. Deputeau created the now famous fictional character Caillou, created the image. And Deputeau worked with Leroux, who wrote text for books. And Deputeau and Leroux entered into an agreement with the publisher, Édition Chouette. And over time, there were issues about the interpretation of the agreements. Actually, there are several agreements. The publisher applied to court for declaration, and then the Deputeau moved under the status of the Artists Act. If you notice, that seems to be the most relevant statute in copyright matters these days. And I bet many of you have never even read it. But you should think about it because it may be relevant sometimes. Deputeau moved under that act to have the matter referred to an arbitrator, presumably because it was cheaper. The arbitrator said Deputeau and Leroux were joint authors, but that they had assigned all their rights to Chouette. On appeal, the Quebec Court of Appeal quashed the arbitrator's award and said that the arbitrator had exceeded his jurisdiction because under the Quebec Civil Code, an arbitrator cannot rule on a right relating to a person's dignity. The Supreme Court of Canada reversed back and said the copyright ownership cannot be equated with the moral rights of dignity contemplated by the Quebec Civil Code, that the moral rights covered by the Copyright Act are really commercial rights, and therefore the arbitrator was fine as long as the arbitrator acted within its mandate. I'm going to come back to this case in a bit. Let's talk about some procedural issues. Proceeding for copyright infringement may be commenced by way of an application. That's Kraft and Euro Excellence. You don't need a statement of claim. Summary judgment. Since 1997, we're seeing cases on that. Bonds and Suzuki, that car case, the court granted summary judgment for the defendant. And in one of the SOCAN cases, the court said summary judgment should not be granted if the necessary facts cannot be found, and that's consistent with the cases over the last few years. A stay. A stay should be granted where proceedings with virtually identical facts and matters have been commenced in both the federal court and the provincial court. That involves Apotex and AstraZeneca, and I just want to tell you that's not a patent case. It's a copyright case involving a drug monograph. Anton pill orders. Chum and Stepowitz. The defendants applied to have an Anton pillar order set aside, and they said the plaintiffs relied on a case that was subject to a subsequent charter attack, and the court said, well, the plaintiffs are required to disclose all material facts. The fact that the case may be subject to a charter attack was not relevant, and so they maintained the order. I want to come back to Deputeau and the jurisdiction of an arbitrator. The court there said that an arbitrator has jurisdiction over the issue of co-ownership because it was intrinsically related to the issues within the terms of reference, namely the interpretation and application of the license agreement. It is interesting because when an arbitrator makes a decision respecting co-authorship or co-ownership, or if you extrapolate to a patent case, co-inventorship or ownership of an invention or a patent or patent application, that may have repercussions vis-a-vis third parties. The court did not specifically say that that holding is inter partes. I think it's implicit, but it's important to just consider the effect of an arbitrator's decision vis-a-vis third parties, particularly third parties who have no knowledge of what the ultimate outcome is. Let's talk about some remedies. Punitive damages, appropriate where infringement has lasted many years and the defendant has shown no concern. An award of $500,000 in Evocation and Hamilton. Statutory damages. You can ask for statutory damages instead of actual damages or profits at any time before final judgment. So you can always, I shouldn't say always, but generally can amend your pleadings. Small claims court jurisdiction. The Dolmage case again. Small claims court does not have jurisdiction to grant declaratory or injunctive relief. You can get money, but you can't get an injunction. Criminal cases. In AFC soccer, the court had to actually deal with figuring out how much the fine should be, and there's not a lot of case law in Canada. The court said that a fine of 25% of gross revenue was appropriate. It seemed to me the accused got away with 75%. Not a bad deal. Collectives. Firstly, music on the internet. The Tariff 22 case argued. I'm going to skip by the retransmission and pay audio and music stations. I'm going to touch on the recordable media case. This is the private copying case. The Act in '98 was amended to permit private copying. The trade-off for that was that a levy could be imposed on blank audio recording media to compensate authors, performers, and makers for people who made private copies. The board released a decision in December on private copies in response to a tariff proposed by the Canadian Private Copying Collective. The board opted to freeze existing levies because the evidence as to the market was unclear. There was evidence that if the levies were raised, it would encourage black market and gray market activity. The court went on to talk about what an audio recording medium is. There are two relevant aspects. First, it has to be used by individual consumers for the purpose of reproducing, it has to be ordinarily used by individual consumers to reproduce sound recordings. And second, on the form of the medium, the definition was meant to be broadly construed and technologically neutral. So a medium that is incorporated into a device remains a medium and may be the proper subject of a levy. This is, bear in mind, a board decision, not a court decision on those issues. The board also said that a zero rating system that had been imposed in an earlier decision of the board, where certain people got to buy levy-free, was constitutionally improper. I'll spend 1 minute on designs. There were no amendments to the Act. The only amendments to the regs were the fee increases, and in the only case of note, it was held that a slight change of outline or configuration or an unsubstantial variation of something did not qualify for design protection. That was, it related to a satellite dish cover. For the reasons I mentioned at the outset, 2004 is going to be a really interesting issue. And as Dawn said, I'm done.
And the first fear of every moderator is that the speaker's going to go overtime. The second fear of every moderator is the speaker's going to go undertime. We have about 8 minutes or so before we're supposed to take the morning break, so I welcome any questions from anyone now. Yep, Richard?
About the academic concept, does that sort of thing apply to research hospitals like everywhere?
It may. It may now. It may.
Wouldn't recognize research done and papers are published that don't recognize that research.
Yeah. It's arguable this case is very fact-specific. It's arguable the case has a minimum value, given that it's a small claims court case. But the principle stated is that it accepts this custom in the trade, if you will, this custom in the environment, and that custom is such that it has now been elevated to an implied agreement, and therefore it's an agreement. So this is, of course, all subject to any actual agreements that people sign. And for example, the teaching hospitals, the universities, the research centers all have agreements with, or for the most part, have agreements with their academics and their researchers, which govern. And if they and often where the agreements don't specifically govern, they incorporate university or hospital or other institutional policies. It also, an argument against this is that a researcher is different than an academic. A researcher is actually doing specific stuff in terms of developing whatever for a client or for the business, as opposed to just sitting back and blue skying academically. So I think there are arguments on both sides now.
My second question was on the idea of copyright. Is anybody threatening copyright argument to fight against FISPA requests for access to documentation that you're aware of?
If you could repeat the question.
Yeah. Oh, sorry. Has anybody used copyright to argue against freedom of information requests? Not that I recall, and there are some exemptions in the Copyright Act for statutes. I think that may be the freedom of information one. May be one. I'm not sure. I'd have to check. But to my knowledge,
Provincial legislation is passed, and they basically want to give, like, you
Yeah.
talk about the compilations here in
Yeah.
Colombia, and there's a whole bunch of photos of them. I just wondered if anybody was actually trying to argue that.
yeah, not to my knowledge. I have a vague recollection that one of the statutes, either the Freedom of Information statute or the it may not be the Copyright Act, but that point is covered off. There's another situation where if a court felt that the whole freedom of information or access to information regime would fall apart, a court might imply a license. So, but I don't know of any. I can't think of anything offhand. If you give me a card after something, if something hits me in the shower tomorrow, I'm happy to deal with. Oh, sorry.
Based on the Copyright Board decision, is peer-to-peer downloading for private use now legal in Canada?
How did I know I'd get that question today? The question is, in light of the Copyright Board case, is peer-to-peer downloading legal in Canada? I can't comment on that because we have been retained by Canadian Recording Industry Association, so I can't mention anything. I apologize. I know that's what you all came to hear about, right?
That's right.
Sorry.
I think it's okay if you do it in the piracy of your own home. Yeah, there's a.
That's where I saw Don's name. It was on the list of infringers. Should we deal with?
Yes.
Should we make anything of what the Supreme Court said about the moral rights in the civil code as having a potential application in the way they're thinking in the common law?
Yeah. Should we make anything of the Supreme Court's comments on moral rights in the civil code as some indication of the way they're thinking in common law? No, I think what they were trying to do is say that the term moral rights in the Quebec Civil Code relate to sort of the dignity of the person, as opposed to the term moral rights in the Copyright Act, which relate to certain enumerated rights such as attribution of authorship, mutilation of the work, and it just may be unfortunate that the same term is used in both statutes, but they really mean different things. I think that's all they were trying to do to get to the result they wanted. I haven't thought about this at all, but I don't think we can read anything more into it. I think there was one in the back.
No, it was the same questions
Oh.
before. Any other questions?
Okay.
Hearing none.
Thank you very much, and so I apologize.
Thanks very much, Sheldon. Well, let's take our 15-minute break now. According to the clock back in the sound booth, it's about a quarter to 11. Let's come back at 11 o'clock.